So today was day 4 in the Wilson's Hospital School versus Enoch Burke High Court case. Remember, the substantive issue here is whether the school was justified in invoking the disciplinary procedure in the workplace or not, and what the High Court has to decide, because it's the school's application that the disciplinary process was validly invoked as a consequence of Mr. Burke's conduct in the school. And we've heard about the conduct from a number of witnesses so far. Today's day 4. We've had 4 witnesses for the school. We've had no witnesses for Mr. Burke. We've had no Mr. Burke today, yesterday, or any of the days apart from the first day when he was put outside the High Court because, in the judge's view, he was unable to conduct himself and basically adhere to the strictures and conduct and rules of the court, and was unable to behave himself, quite frankly. At every turn and every day during the hearing, and again today, it was made clear to Mr. Burke by the judge that he was free to come in along with his sister and participate in the hearing if that's what he wanted to do, but he just needed to give an undertaking to the court that he would not engage in inappropriate conduct, which the judge found to be the case on Tuesday when the hearing kicked off. So today then there was no evidence. Today it was a question of submissions. Both parties, both sides put their own submission. The school had 2 senior counsel, Mark Connaughton, senior counsel, and Alex White, senior counsel, and they both made submissions today at various junctures. The judge then said, when the hearing was finished in the afternoon, that he would make his decision pretty quickly. And around about 11 o'clock in the morning or thereabouts, an email came in for the judge. It went to the court registrar. Apparently it was, quote, a big long email from Enoch Burke. The judge read it and he went off to his chambers and came back and read it and basically rejected vehemently all of the allegations and contentions that Mr. Burke had in his email. Later on then, around lunchtime at 1 o'clock or thereabouts, Mr. Burke arrived with his mother and his sister and stood outside the forecourts in front of a camera and a number of cameras and read out his email, which he had already sent in to the High Court. A guard came out and told him that he was free to come in. The guard came with a message from the court that he was free to come in and participate, but Mr. Burke declined and left the place. The judge said he was tempted to give his judgment today, but he didn't. He held off. He said he was a little bit tired. He said his provisional view was that even if the school had acted entirely incorrectly in relation to the procedures surrounding Mr. Burke's suspension, there was a clear case of trespass, and Mr. Burke was not entitled to go back on school premises. He said he would give his judgment fairly shortly. Senior counsel Alex White for the school said the school entirely rejected any question that the disciplinary action being taken against Mr. Burke because he had held any particular views, including religious views. He said Mr. Burke has never been required to deny his religious beliefs. He had every right to hold views, but that did not extend to a right to act without limit or restraint where his rights conflicted with the rights of others. Mr. Burke was not in court. Mr. Justice Owens told him on Tuesday that he could not come back into the court until he was willing to accept the court's ruling. Mr. Burke, as I say, sent an email today. It was read out and the judge rose for a short time and read the email in his chambers and came back in and vehemently rejected all of the assertions and allegations in the email. Mr. Burke claimed in the email that he was unjustly barred from the hearing of the action. He repeated his allegations about the disclosure of documents. To him, he said he had been repeatedly laughed at, mocked and ridiculed by the judge, and he said when he pressed the matter, the judge had suggested he should be carted off to Mountjoy Prison. Despite the fact that solicitors for the school had written to Mr. Burke the following day on the disclosure issues, Mr. Burke said almost all the issues had remained unchanged. He said it was unconscionable for the case to go ahead and to be allowed to proceed. He claimed that the judge had made it a condition that he accepted the issues he raised were flimsy, stupid and a waste of time. So that's one of the reasons why he wouldn't participate. He took the view that that's what the judge was basically saying on day one, morning one. Mr. Burke also claimed that the chairperson of the Board of Management, John Rogers, had avoided service of a subpoena from him. He said he visited Mr. Rogers' home at 10:50 p.m. on Monday night before the hearing started, and he said his wife told him she was not at liberty to tell him where Mr. Rogers was. The court has been told that Mr. Rogers is not in court because he's in hospital. It's also understood that Mr. Burke served a subpoena on the former principal of the school, Niamh McShane, who was already a witness in the case for the school. He turned up at her home as she returned home from work one evening last week. In response to the email, the judge basically rejected all the points made by Mr. Burke. He said Mr. Burke's conduct in court was completely unacceptable, and sometimes it was necessary for a judge to actually call a spade a spade. The judge said the issue of the disclosure of documents had been dealt with to the satisfaction by lawyers for the school, and Mr. Burke could have come into court if he had indicated he was prepared to abide by its rulings and had an intelligent, frank and informal exchange of views in relation to any of the issues raised. Just to be clear about that, the disclosure of documents issue that was raised by Mr. Burke, the judge said they had been dealt with to his satisfaction by lawyers for the school. The judge said it was obviously a preliminary letter in advance of some other onslaught. This is the email from Mr. Burke, and it was an attempt to litigate by correspondence. He said Mr. Burke should have turned up to raise the matter in the normal civilised way litigants behave in court. The judge said you could not win a soccer match by running away with the ball. The ball had been replaced and the match would continue. Senior counsel Mark Connaughton said Mr. Burke had been communicated with by lawyers for the school on a number of occasions by email, not just to deal with the disclosure of documents, but to communicate with him that he was welcome in court if he accepted the judge's directions. He said the disclosure issues had been dealt with and an explanation for each issue had been given in a specific way. In his closing statement, Mr. Connaughton told the court the way Mr. Burke had conducted himself at a school event on 21st of June was extraordinary, and his conduct towards the then principal, Miss McShane, was unacceptable. He said she was entitled to pursue it further and formed the view that dealing with this matter as gross misconduct was appropriate as a mechanism to pursue it further. He said she had no animus towards Mr. Burke beyond extremely dissatisfied with how he behaved, and it was up to the Board of Management to decide what should happen. Mr. Connaughton said the disciplinary process had been validly invoked, and that's the key question here. Was the disciplinary process validly invoked? Mr. Connaughton said Mr. Burke could have been in no doubt at a meeting of the board of 22nd of August as to what the allegations against him were. He said this was a man who had set his face against any form of cooperation, and the school had grounds to fear that Mr. Burke was going to repeat some of the behaviours it was concerned about. Mr. Connaughton said the meeting on the 22nd of August was not a normal one, as Mr. Burke and his sister Amy, who accompanied him, would not let it be a normal meeting. They did not come to the meeting to engage with the issues, he said. They came to engage in their own agenda. He said the decision to place Mr. Burke on suspension pending a disciplinary hearing, which was due to take place a few weeks later, was entirely valid and unassailable. Mr. Connaughton added that Mr. Burke had then disobeyed the lawful instruction of the school to suspend him. He said he had attempted to completely torpedo the disciplinary meeting that eventually took place in January this year. The court was told yesterday that Mr. Burke, his brother Isaac, sister Amy and mother Martina repeatedly chanted and shouted, disrupting that meeting, "Where is John Rogers?" That's day 4 of the Wilson's Hospital versus Enoch Burke case. Couple of points. Senior counsel for the school let the court know yesterday or the day before that Mr. Burke is still being paid. In other words, people will look at this video and wonder what's the next step after this. Obviously, the outcome of this, the decision or determination by Judge Alexander Owens, will be important and will determine who goes where and that sort of thing. But obviously, Mr. Burke still has the appeal of the dismissal or the suggestion or recommendation that he be dismissed. So he has that appeal. It's in accordance with the circular letter for schools, for the disciplinary procedure in schools, and he has an appeal. I've dealt with that before. It's a circular letter from 2018. That has to come up yet, and presumably until that particular group or committee, I think there's 3 persons on it, until they make a decision about any appeal from Mr. Burke, and there is an appeal gone in, then he will presumably continue to be paid. So that is the situation with Enoch Burke and Wilson's Hospital School. And another interesting point, I suppose, is that there was 3 clerics in the High Court for 4 days, all of whom had been subpoenaed by Enoch Burke to give evidence, and none of whom were asked a single question. Also, Mr. Burke didn't test or contest the evidence advanced or given by the 4 witnesses for the school, and ultimately in any dispute it's a question of both parties putting their best foot forward, both parties hoping that they will win, but obviously there is always a risk. There's always a risk with any contest, whether it's football or hurling, whether it's law or a court case. There's a winner and there's a loser, and sometimes there's a certain nobility, I believe, in putting your best foot forward, trying your best and taking it on the chin then whether you win or lose. Obviously people who play a lot of sport understand this from an early age, because the experience of winning, the experience of losing, the experience of frustrating referees' decisions and so on are actually part of growing up, part of life. And but there is, as I say, a certain nobility of putting your case and putting your trust and your faith in the hands of the decision maker. Unfortunately this week Mr. Burke didn't do that. He had a submission to make, he had witnesses to cross-examine, he had witnesses to take through direct evidence, but none of that happened. So where it goes from here, I don't really know. Obviously the judge is going to make his decision pretty quickly, and I wouldn't be surprised to see the decision next week, because quite frankly the judge said today that he was tempted to make his decision today, and I don't believe it's looking good for Mr. Burke, quite frankly, but I don't know. I'm just speculating. That's the story. If you think this video is useful, I'd appreciate if you gave it the thumbs up down below. Thanks a lot.